Right now, at this very moment, millions of law-abiding American gun owners are waiting on a decision that could change everything. The Supreme Court of the United States is sitting on one of the most explosive Second Amendment cases in years, and they keep delaying, relisting, and going silent. The case is called Duncan versus Bonta, and if you own a firearm, if you believe in your constitutional rights, if you live in California or any state that has magazine restrictions, you need to understand exactly what is happening right now, because the outcome of this case could ripple across the entire country. So stay with me, because we are going to break this down from the very beginning, all the way to where things stand today in March 2026, and what it all means for you. And if you're new here, hit that like button and subscribe right now, because we cover Second Amendment news and legal battles like this every single week, and you do not want to miss what's coming. Let's start from the beginning, because to understand why this case is so massive, you have to understand how we got here. Back in 2016, the state of California passed Senate Bill 1446. That law made it illegal to possess what California called large capacity magazines, which they defined as any magazine that can hold more than 10 rounds of ammunition. Later that same year, California voters passed Proposition 63, which took that law even further. Not only did it keep the possession ban in place, it added real criminal penalties for anyone who refused to comply. And here's the part that really made gun owners furious. The law didn't just say you couldn't buy new standard capacity magazines. It said you had to get rid of the ones you already legally owned. You had to surrender them to police, sell them out of state, or destroy them. Think about that for a second. You went to a store, you paid your money, you followed the law, you brought those magazines home. And then the government turned around and said, give them up or face criminal charges. That is not a small thing. That is the government reaching into your home and taking your lawfully purchased property. So a group of gun owners decided to fight back. Virginia Duncan and several others, along with the California Rifle and Pistol Association, filed a lawsuit in 2017 in the Southern District of California. They argued two things. First, that this magazine ban violated the Second Amendment. Second, that forcing people to give up property they legally bought without any compensation violated the Fifth Amendment's takings clause. In other words, if the government takes your stuff, the Constitution says they have to pay you for it. The case landed in front of Judge Roger Benitez, a federal district court judge who is well known in Second Amendment legal circles. And Judge Benitez did not hold back. He struck down the law. He ruled it unconstitutional, finding that it violated the Second Amendment. Gun owners cheered, but California wasn't done. The state appealed, and the case began its long, winding journey through the federal courts. Now here is where it gets complicated, and here is where history starts to matter. In 2022, the Supreme Court handed down a landmark decision called New York State Rifle and Pistol Association versus Bruen. That case completely changed the legal framework for evaluating Second Amendment challenges. Before Bruen, courts were using what's called a two-step balancing test. They would weigh the government's interest in safety against the burden on gun rights. After Bruen, the Supreme Court threw that out. The new rule said that gun regulations must be consistent with the historical tradition of firearm regulation in America. Meaning, if the government wants to restrict your gun rights, they have to find a historical analogue, a similar law from the founding era or the 19th century, to justify it. That was a massive shift, and it sent shockwaves through gun law litigation across the country. It also directly affected Duncan versus Bonta. The Supreme Court took the case, vacated the lower court ruling, and sent it back down to the Ninth Circuit for reconsideration under the new Bruen standard. So now we're back at the Ninth Circuit. And this is where things get really frustrating for Second Amendment supporters. Instead of just reconsidering the case with a regular three-judge panel, the Ninth Circuit assigned the case to what is called an en banc panel, meaning a large group of judges sitting together to hear the case. And this is something that Second Amendment advocates have pointed out repeatedly. It seems like whenever a gun rights case shows up at the Ninth Circuit, it gets assigned to the full bench, which tends to be more liberal and more willing to uphold gun restrictions. The en banc panel heard oral arguments in March 2024. Then everyone waited. For nearly an entire year, there was silence. And then on March 20th, 2025, the Ninth Circuit issued its ruling. The en banc court upheld California's magazine ban in a 7-4 decision. They ruled that the ban did not violate the Second Amendment. They also rejected the Fifth Amendment takings claim. But here's what made the dissent so powerful. And this is important. 4 judges dissented, and the dissenting judges did not hold back. Judge Bumatai, joined by Judges Ikuta and Nelson, wrote that the majority completely failed to apply the Bruin standard correctly. Under Heller and Bruin, the analysis is supposed to be rooted in the text, history, and tradition of the Second Amendment. The dissenters argued that the majority twisted the historical record and ignored the proper legal framework. Judge Van Dyke went even further. He actually recorded a video of himself handling different handguns to illustrate how magazines work mechanically, trying to show that magazines are an integral part of a firearm, not a separate accessory that the government can freely ban. That video caused some controversy among the judges on the majority side, but it made Van Dyke's point in a very vivid, memorable way. The majority, however, ruled that standard capacity magazines are not commonly used in self-defense, in a way that gives them constitutional protection, and that the ban is consistent with America's historical tradition of regulating deadly weapons. Gun rights advocates were outraged. Critics argued the majority was doing exactly what Bruin was designed to prevent, cherry-picking historical examples and applying a framework that effectively guts the Second Amendment. The California Rifle and Pistol Association immediately announced they would take the case to the Supreme Court without delay. And that brings us to August 2025. On August 15th of 2025, the plaintiffs filed a petition for a writ of certiorari with the United States Supreme Court. That's the formal legal request asking the justices to take the case and review it. The petition raised 2 central questions. First, does banning the possession of exceedingly common ammunition feeding devices, magazines that tens of millions of Americans legally own, violate the Second Amendment? Second, does a law that forces citizens to give up property they lawfully purchased and long possessed, without any compensation, violate the takings clause of the Fifth Amendment? Those are 2 enormous constitutional questions, and they affect not just California, but every state in the country that has passed similar restrictions. Support poured in from across the country. 27 state attorneys general filed what are called amicus briefs, friend of the court briefs, supporting the petitioners, and urging the Supreme Court to take the case. That is a massive show of legal support. The NRA threw its weight behind the challenge as well. California Attorney General Rob Bonta filed a response defending the ban, arguing it is consistent with America's historical tradition of regulating dangerous weapons. So both sides were loaded up and ready to argue. Now here is where we get to the most recent and most nerve-wracking part of this whole story, and why gun owners across the country are watching their phones and checking legal dockets every single week. The case was first distributed for Supreme Court conference on November 21st, 2025. For those who don't know, a Supreme Court conference is when the 9 justices meet privately to discuss petitions and decide whether to grant review. It only takes 4 justices to agree to take a case. Gun owners were hopeful. But then something unexpected happened. The conference date was suddenly rescheduled, with no explanation given. Just one word on the docket: rescheduled, no new date, nothing. That sent the Second Amendment community into a spiral of anxiety and speculation. Eventually, the case was redistributed for a December 12th conference, then again for January 9th, 2026, then January 16th, then January 23rd. After each conference, the orders list came out, and Duncan was not on it. No cert granted, no cert denied, just silence followed by another relist. This is called relisting, and while it is not unusual at the Supreme Court, the repeated relisting of Duncan has been deeply unsettling for everyone watching. Legal experts have explained that relists can happen for several reasons. The justices might be drafting a summary reversal, meaning they could be preparing to reverse the Ninth Circuit without even hearing full oral arguments. Or one or more justices might be writing a dissent from denial of certiorari, a written statement objecting to the court's decision not to take the case. Or the court might be waiting to see how related cases develop before making a move on Duncan. As of right now, mid-March 2026, the case remains in this uncomfortable limbo. The Supreme Court has not granted cert, but they have not denied it either, and the stakes could not be higher. If the court denies certiorari, the Ninth Circuit's ruling stands. California's magazine ban remains in full force, and millions of gun owners, people who legally purchased standard capacity magazines during periods when injunctions were in place, could suddenly find themselves in violation of state law, potentially facing criminal penalties for possessing property they bought legally. Attorneys for the plaintiffs have been clear. This is exactly why the Supreme Court needs to act. Refusing to take this case would leave millions of Americans in legal limbo and would effectively allow the Ninth Circuit to ignore the Bruin standard entirely. There's also a broader legal picture developing here. A new court split is emerging. The DC Circuit recently ruled that bans on commonly owned magazines do not meet the Bruin test, directly conflicting with what the Ninth Circuit said in Duncan. When different federal circuit courts reach opposite conclusions on the same constitutional question, that is called a circuit split. And a circuit split is one of the most powerful reasons for the Supreme Court to step in and resolve the conflict. With the Ninth Circuit saying magazine bans are constitutional and other courts saying they are not, the legal landscape for gun owners varies dramatically depending on what state they live in. That is not how constitutional rights are supposed to work. Your Second Amendment rights should not evaporate the moment you cross a state line. Justice Brett Kavanaugh has previously signalled that the court should address bans on commonly owned weapons and accessories in the near future, and with the current composition of the court, a 6-3 conservative majority following the landmark Heller, McDonald and Bruin decisions, many Second Amendment advocates believe this is the best chance in a generation to get a definitive ruling protecting standard capacity magazines from government bans. But the court's repeated silence has also fueled fears. Some observers worry that even the conservative justices may be divided on how far to push gun rights protections. Others speculate about internal debates over how to apply Bruin after the court's 2024 decision in United States versus Rahimi, a case that explored the limits of the Bruin framework, may have complicated the calculus. There is also a political dimension that cannot be ignored. The court is keenly aware of how explosive Second Amendment rulings can be in the broader public and political landscape. The prolonged relisting pattern in Duncan echoes what we have seen in other politically charged cases, where the justices appear to be treading carefully, perhaps waiting for the right moment or the right case posture before pulling the trigger. Pun intended. But here is the thing. Every conference that passes without a decision is not a neutral outcome for gun owners. Every month of delay is a month where millions of Californians remain under a law that many constitutional scholars believe clearly violates the Second Amendment. Every relist is another day that a law-abiding gun owner in California has to wonder whether the property they legally purchased is about to make them a criminal. And this case is not just about California. There are states across the country that have passed or are considering magazine capacity restrictions. If the Supreme Court ultimately grants certain rules in favour of the plaintiffs, those laws could fall like dominoes. That would be one of the biggest Second Amendment victories since Bruin itself. If the court denies cert or rules for California, it sends a very different message, that states have broad authority to restrict what kinds of ammunition feeding devices their citizens can possess, even when those devices are owned by tens of millions of Americans for entirely lawful purposes like self-defense, sport shooting, and target practice. The plaintiff's argument is straightforward and powerful. Magazines capable of holding more than 10 rounds are not some exotic military hardware. They are the standard configuration for the most commonly sold handguns and rifles in America. When you walk into a gun store and buy a Glock or an AR-15 style rifle, the magazine that comes in the box likely holds more than 10 rounds. That is what the manufacturer designed. That is what the market developed. That is what hundreds of millions of Americans already own. Saying you can keep your gun but not your standard magazine is like saying you can have a car but not the engine that came with it. The Second Amendment protects arms in common use for lawful purposes. And by any reasonable definition, standard capacity magazines meet that test. California's argument on the other side is that reducing magazine capacity saves lives in mass shooting situations by forcing shooters to pause and reload, giving potential victims a chance to escape or intervene. That is the policy argument the state has made consistently. But Second Amendment advocates respond that the same pause also affects law-abiding citizens defending themselves. A home intruder does not follow capacity limits. A person defending their family in the middle of the night does not have the luxury of pausing to count rounds. Restricting a law-abiding citizen's magazine capacity does not disarm criminals. It just makes the law-abiding citizen less prepared for the worst moment of their life. So here we are in March of 2026, watching and waiting. The case is still alive. The Supreme Court has not walked away from it. And that matters. There are legal observers who believe the repeated relists actually signal serious engagement. That justices are wrestling with the case, reading briefs carefully, perhaps building toward a major ruling. The fact that Duncan has survived this many conferences without being denied outright is itself meaningful. The court is thinking hard about this one, and with the circuit split now firmly established, the pressure on the justices to resolve this question is only growing stronger. For gun owners in California and across the country, the message is the same. Stay informed, stay engaged, and do not give up. This case has been fought for nearly a decade. It has survived multiple rounds of lower court decisions, a remand from the Supreme Court, an en banc Ninth Circuit ruling, and a marathon of relisting. The fight is not over. It may be entering its most decisive phase right now. This is the kind of case that defines what the Second Amendment means for the next generation of Americans. It will answer the question of whether the government can strip law-abiding citizens of property they legally own. It will clarify whether the Bruin standard actually has teeth, or whether lower courts can continue to bend and twist it until it means nothing. And it will determine whether standard capacity magazines, owned by tens of millions of Americans, are constitutionally protected or not. So what do you think? Should the Supreme Court take this case? Do you believe the California magazine ban is constitutional, or does it clearly violate the Second Amendment? I want to hear your opinion in the comments below. Drop your thoughts, share your experience if you're a California gun owner, and let's have a real conversation about this. And if you found this breakdown valuable, please share this video with someone who needs to know what's happening with their Second Amendment rights right now. Sharing this video is one of the best ways to make sure this information reaches the people who care about it. We will be watching this case closely and bringing you updates as soon as the Supreme Court makes its next move. So make sure you are subscribed and have notifications turned on so you do not miss a single update. This fight is far from over.